reaches the Supreme Court, we get an opinion for the court by Justice Kennedy. As we noticed before, he seems to be the strongest member of the current court on First Amendment issues, so that's no big surprise. He's joined, oddly enough, Sotomayor and Ginsburg joined, that's no big surprise. He's joined by Chief Justice Roberts, joins in his opinion. And then that's only 4 justices deciding the case for Alvarez. The majority and the decision is governed by the 2 concurring justices, Breyer and Kagan, who agree with the result. The law is unconstitutional, but not on Justice Kennedy's reasoning. And then Alito dissents along with Scalia and Thomas. But look at the court's, Justice Kennedy's reasoning for the court. The first issue that the court deals with is whether false statements are a category of speech that does not enjoy any First Amendment protection. And there were statements in several decisions, including Gertz, for example, dealing with libel, the Hustler case that we'll consider right after break. There are several statements in Supreme Court opinions that false statements make no contribution to the marketplace of ideas. They have no First Amendment value. And the government seized on those statements and said, look, false statements are a category of speech, like obscenity, that has no First Amendment protection. And Justice Kennedy recites, this is the longest list of unprotected categories that I've seen in any of the court's decisions. Remember the Stevens decision, the animal cruelty case, they listed several categories of unprotected speech. This is the most comprehensive one I've seen, page 221 of the reader. The categories that the court has historically recognized are inciting imminent lawless action, that's Brandenburg, this is like a review of our course, obscenity, defamation, Sullivan, citing Sullivan and Gertz, speech integral to criminal conduct, that is, you know, I'll pay you $1,000 to kill my wife, that speech is unprotected. Part of a conspiracy to commit a crime. Fighting words, under Chaplinsky, the Jehovah's Witnesses case, child pornography, fraud, citing one of the commercial speech cases, that would include false advertising, true threats, real threats, not just idle threats, but real, serious threats that a reasonable person would take seriously, and Pentagon Papers type grave, immediate, irreparable harm to the national security. That's the list. These categories, Kennedy says, have a historical foundation in the court's free speech tradition. Absent from these few categories is any general exception for false statements. The court has never recognized that false statements are, all by themselves, a category of unprotected speech, and the court is unwilling to declare now that merely because it's false means that it has no First Amendment protection. And the court distinguishes cases like Sullivan, cases like the Hustler case, on sort of the breathing room notion, saying that those cases did not say that false speech is completely unprotected. It said, those cases said that some false speech must be tolerated constitutionally in order to provide breathing room to protect free speech, from true speech, from being discouraged. As you'd be afraid to say something that's true if you're not certain that it's true, and it might turn out to be false. And then the court distinguishes the federal laws that make other kinds of lies a crime, and that the court has never questioned the constitutionality of these laws. One of the most famous is, and it's charged in many, many, many federal prosecutions, is 1001 of the Federal Criminal Code, 18 U.S.C. 1001, that prohibits, makes criminal, false statements to a government agent about a material matter. And the government charges that all the time. I mean, if you fib to the Internal Revenue Service about your income, you're going to be charged with 1001. Perjury, under the federal perjury law, lying under oath, is a crime that the court has always upheld. Well, in Alvarez, Justice Kennedy distinguishes those situations because there the lies actually interfere with important government functions and processes. I mean, if people are allowed to lie in court, justice can't be done. If they're allowed to lie to federal officers who are trying to solve a crime or to fix up the economy or something, or fix up your taxes, that the government function will be interfered with. Whereas purely lying, just lying about a medal, doesn't affect any other government function. You may or may not find that persuasive. Justice Kennedy emphasized that this medals law was broad in the sense that it applied at any time, in any place, made to any person. To the guy next to you on the bar stool, whispered in the privacy of your home. It's still a federal crime. And Justice Kennedy said there's no limiting principle, that the government could, if this law is valid, make up a list of subjects about which false statements would be punishable. Short answer on false statements, is that the court concludes that's not a category unprotected by the First Amendment. It may be protected in some circumstances. Having dismissed the government's argument that this is a category of speech not protected, then what's the analysis? Well, it's the conventional First Amendment analysis for a content-based statute, which this clearly is. It's aimed at statements about receiving the medal or not. That's content-based. That triggers strict scrutiny, compelling government interest, and narrow tailoring to serve that interest. Justice Kennedy says, which has been said many times before by the court, if it's content-based, the statute is presumed unconstitutional, and the burden is on the government to show compelling interest and narrow tailoring. Kennedy finds, a little bit offhanded, but he actually finds that the government interest here is compelling. The government interest in maintaining the integrity of the medals program is compelling. So the question is one of narrow tailoring, and he says, and he did not invent this, there's precedent for it in previous cases, that narrow tailoring requires that the restriction be actually necessary to serve the government interest, and that there be a direct causal link between the restriction imposed and the injury to be prevented. Pretty tough, narrow tailoring points. And Kennedy concludes that the government has not met the narrow tailoring test because it didn't produce any evidence to show that the public's respect for medals or medal winners was in fact diluted by false claims by people like Alvarez. The government hadn't shown that making it a crime was actually necessary to preserve the integrity of the medal program. Nor, Justice Kennedy concludes, has the government shown that counter-speech would not satisfy the government's interest, and says that the remedy for speech that is false is speech that is true. That echoes Justice Brandeis's great opinion in Whitney versus California that I referred to time and again, where the idea is if speech is dangerous in some way, subversive, the government doesn't like the speech, the proper remedy for that is not suppression of the speech, but more speech. Counteract bad speech with good speech. And in this case, in Alvarez, even before the FBI conducted its investigation, there had been counter-speech. Alvarez had been called a phony, a sleazebag, perpetrating frauds, compulsive liar. The press was all over him for having said this, and then he was prosecuted. And finally, Justice Kennedy says that in order to be narrowly tailored, the government has to choose the least restrictive means of serving its interest, the means that is least restrictive of speech. And what was suggested to the court, and what Justice Kennedy said is less restrictive than making a lie a crime, is for the government to compile a database of medal winners, easily searched on the internet, so that people can find out who won medals and who didn't. And that's much less restrictive of speech than making it a crime to say you won a medal when you didn't. Sort of lurking in the background, and this came out at the oral argument in the Supreme Court, what animated Justice Kennedy and the six who voted against this law is that they didn't want to get into the business of lies about politics, the politicians' lies. I mean, who lies to the public more than politicians? They lie about their military service. They lie about their degrees, their academic degrees. Senator Rubio from Florida lied in his official Senate biography about when his parents came to this country. He says they came after the Communist Revolution. In fact, they came before. Certainly the government would have as strong an interest, if you're talking about important government interests, in protecting the integrity of the electoral process and preventing voter deception, as it does in the medal situation. But the court doesn't want to allow the government to get into the business of prosecuting, because what about if you lie about your opponent or your opponent's record? That's a real can of worms that the court doesn't seem to want to get into. Well, what's going on with Justice Breyer and Justice Kagan joining him here? Why couldn't they join the opinion written by Kennedy? They concur only in the result, not in the opinion. And you read the first couple of pages of Breyer's opinion, and it's pure Breyerism, waffling. He's unwilling to embrace the very notion of strict scrutiny. I think he views it as too binary. You know, if it's strict scrutiny, that necessarily means the statute's unconstitutional, and that isn't the way the law ought to work. It ought to be more nuanced. We ought to look more carefully at the facts. We ought to weigh and balance the interests of the parties on a case-by-case basis, not to paint with a broad brush. So what he's advocating, and he seems to be advocating it across the board for all kinds of First Amendment cases, is intermediate scrutiny, which would require the government to show that they have some kind of an interest that is worth protecting. I don't know what label you put on it, substantial, important, something like that, and that the law doesn't infringe too much in the way of speech, but most importantly, that it doesn't unnecessarily restrict speech. And he says that this law does violate intermediate scrutiny. It threatens First Amendment harm, he says, because sort of the notions that Kosinski raised by all of his examples about how much we all fib about ourselves. If the government's going to criminalize things like that, that threatens First Amendment harm, in Breyer's view. But I think the more important thing is that he says that there is a less restrictive alternative here, not necessarily the database mentioned by Kennedy, but that the Congress could write a more narrowly targeted, focused law about medals. And what would it say? How could it possibly be more narrowly tailored than lying about the Congressional Medal of Honor is a crime? Well, it could be, for example, if the lie caused harm. Only lies that cause actual harm to some identifiable person could be a crime. Or a lie about the medal for the purpose of making money or getting an office, attaining some benefit by virtue of your lie, like fraud. Then that would be more narrowly tailored than simply lying regardless of the context. And since there is this less restrictive alternative, this law is unconstitutional. Alito's dissent points out how narrow this law really is, how targeted this law really is, how very limited the law is. And he recalls the moment in oral argument in the case where he asked the lawyer for Alvarez, who was a courageous deputy public defender from Los Angeles, who handled the case from the beginning, argued in the Supreme Court of the United States. He said to the lawyer, what valuable or truthful speech would be chilled by enforcing this law? Is there a good answer to that? The lawyer answered, none. which allowed Alito to argue in his dissent that there is no constitutional value in false statements, and that the court should say so. Well, then, is the lesson of Alvarez that we all have a constitutional right to lie? What a triumph. What a wonderful system we have here in the United States, where we have a constitutional right to lie. I think that's the wrong way to characterize the case. The question, as I view it in the Alvarez case, is not whether there's a constitutional right to lie. It's a question of the extent of legitimate government power over us as individuals and what we say about ourselves. And the court appropriately drew the line, stopping the government from making lies about all kinds of things, crimes. I think that the First Amendment requires that we start with a presumption that whatever we say, we are free to say whatever we want, unless the government can justify a restriction. The idea is not to say falsity is unprotected, unless it's necessary in order to give breathing space to something, which is the dissent's presumption. So, questions about Alvarez, or where we are? Other things? What are you going to do next week? Let's see, you're going to read Make No Law, and you're going to Lewis's book, and you're going to research completely your paper, and have the first draft ready for your editor upon your return. And in the meantime, you can weep over your midterms. Take your time. We got a lot of time for it.